This lesson is a conclusion for the classification of types of law. Generally, there are mainly two types of law. These are public law and private law. The former is a branch of law which is concerned the relationship between states and people, or so-called public law. The latter is the branch of law which is governed between people and people, or so-called private law. Public law is the branch of law which is concerned its sovereign capacity. The branch of law is composed of the subjects as follows. First, criminal law is a law connected with or involving crime. It is related to a person who commits a crime. The study on criminal offenses and criminal punishment. Second, international law is the study of relationship between two or more countries. It involves the area of cooperation on a conflict, for example, the law of wars, or international humanitarian law, law of the sea, or international criminal law, etc. And the last one, administrative law is concerned with the origin and fundamental concept of administrative law, the concept of administrative actions, administrative contracts, and administrative controlling systems. It's all about the people and the state. Normally, the state that we talk about under administrative law is about the state official or the state officer, or we call government officer who does the duty. And that kind of duties make some kind of conflict with the relation with people when they order the thing to violate the rights of people. So this kind of law protect the people to sue the government or to sue the state officers who did wrong on their duty. On the other hand, we talk about private law. What is it? Private law is the branch of law which is concerned between citizen and citizen equally. This branch of law is composed of these subjects as follows. First, juristic act is an act of a person designed to have a legal effect. It is an act of individual directed to create, modify, transfer, preserve, and extinguish rights. Second, contract law. Contract law is the study of the agreement between two or more persons that creates, modifies, or terminates the legal relation. Third, tort law is a study on the person who has suffered a wrong caused by another person can use civil litigation to exact legal remedies, most notably compensation from the wrongdoer, or we call wrongful act, normally in Thai civil and commercial code. And another word for compensation you can call as damages. It's the same meaning of compensation, means sum of money that injuring person has to pay back to the injured person or the victims. Fourth, partnerships and company law is the study of operating business with objective to gain profit. It is divided into two forms: a sole proprietorship, or a business owned by a natural person with unlimited liability, and a partnership or company that begins or starts with two persons at least. Fifth, property law. Property law governs relationships among people with respect to things or property. It also includes modes of acquisition of the property, for example, capture or creation, or co-ownership of the property, title recording systems, easements, and other related land issues is about the property law. You think about immovable and movable property. Immovable property, for example, land and house. On the other hand, movable property, for example, a car, motorcycle, or your gold. Sixth, family law. Family law is a study of the relation of all members in the family, father, mother, and children, and also husband and wife, or even if the new modified law of Thailand we call partners in the relationship, both transgender or same-sex marriage, for make it equally to have the right to create or establish the family without unequal with the gender, okay, or relations of the couples. For example, condition of engagement and marriage, and include the same-sex marriage nowadays. Seventh, succession law or heritage law is the right and transmission of the rights and obligations of the owner who died. Succession law is about the right and duty, including responsibility of the dead person. Make a will, W-I-L-L, will, the statement or the letter that was written by the dead person decide to give that property after they die. For example, I make the will to give all my property to the foundation or to give all my property to my husband. This kind of thing we call will. Or if you don't make the will by yourself, the law makes some kind of law as the legal heir to get the property because you are the children of the dead person or you are husband or wife of the dead person. You will get this kind of right or receive this kind of right because of you are the heir without making the will. But if there are wills, the will is more powerful than the legal title made by the law. Next, I will talk about common law and civil law systems. Civil law is derived from ancient Roman law and originated in Europe on basis of Roman private law that was applicable to citizens and between the citizens within the boundaries of the state in the domestic context. Civil law starts out with abstract rules which judges must then apply to various cases before them. The civil law country's legislation is seen as a primary source of the law. Therefore, courts thus base their judgments on the provisions of the codes or statutes and have to reason extensively on the basis of general rules and principles of the court or act created by legislature or legislative power. These methods often draw analogies from statutory provisions to fill lacuna and to achieve coherence. By the contrast, common law system is based on English common law model, predominantly founded on the system of case law or judge-made law system, or we call judicial precedent. And legislation has not traditionally been regarded as the primary source of law, but has usually been regarded as mere consolidation or clarification of legal rules and principles which are essentially derived from case law and judge-made law. Next is about introduction to Thai law. This is about overview of Thai legal system and basic laws. The Kingdom of Thailand is a constitutional monarchy with a parliament or parliamentary form of government, or we call National Assembly. Thailand uses a civil law system and its primary laws are embodied in Acts of Parliament. The Acts are supported by a variety of administrative laws and regulations issued by the Thai Cabinet and permanent ministries according to law made by executive power. These regulations include royal decrees, ministerial regulations, notification of the Directors General, as well as less formal policies and procedures adopted by departments within the Thai government. The policies have not gone through the formal legal process, but as a practical matter, can be as important as an act of parliament for one doing business in Thailand. What about Thailand legal system? Thailand laws follow the pattern of civil law countries of continental Europe. When a dispute is brought before the judge, the court will decide the case based on an interpretation of statutory provisions. The court's interpretation is not as broad as that a court in a common law country and unlike the common law court. Its decision will not develop the body of law, although interpretations by the highest courts or so-called Dika Court or Supreme Court in Thailand become precedent under the doctrine of stare decisis. Thailand laws derive from two major sources. First is legislative branch and the second is executive branch or cabinet. Both central and local governments can create the law. The judicial decisions are not law because they are applied to individuals, notwithstanding the fact that the court will normally adhere to precedent for subsequent cases with the same situation in order to attain stability of fairness. Reversal based on decisions, however, does not happen very often in Thailand. I would like to talk about types of law in Thailand. I will begin with the first one. It's the highest law in Thailand we call constitution or constitutional law. In the full name of Thai constitutions, we call the Constitution of the Kingdom of Thailand. A constitutional law based on the powers and the relationship of the three branches of the government to each other and the relationship between the government and citizens in regards to fundamental rights and responsibilities. Next is about acts. An act is the most common known law and is made by Parliament or National Assembly in Thailand. For example, Copyright Act, Trademark Act, and Investment Promotion Act. Next, Emergency Decree. Emergency Decree is enacted by Executive Branch. This level or this kind of hierarchy is equal with Act. So, Emergency Decree is enacted by Executive Branch through Cabinet in an emergency to protect the country from imminent harm, but subject to subsequent confirmation of the Parliament. Next is about Royal Decree. A Royal Decree is promulgated by Executive Branch, normally through the Minister of the concerned ministry, authorized under the specific act to set forth the details from time to time under the guideline of the Act. For example, a royal decree to receive the tax rates under the Revenue Code. Codes is the collection of law made by the legislative branch, normally used in civil law legal system. Example, first, Civil and Commercial Code of Thailand. Second, Penal Code of Thailand or Criminal Code of Thailand. Third, Civil Procedure Code of Thailand. And fourth, Criminal Procedure Code of Thailand. And there are not only 4 codes that I talk about. It's also Revenue Code and Land Code of Thailand. There are many important as a tool used by Thai courts because Thailand's legal system uses civil law system, not judgment law system like common law system. On the other hand, those codes can be categorized into substantive and procedural laws that I talked before in our classroom. Thai Civil Commercial Code and Thai Penal Code are substantive law, while civil and criminal procedure codes of Thailand are procedural law. I would like you guys prepare well for our exam. May the force be with you. Love you.